Thanks, Patricia. Welcome to Supporting LGBTQ plus immigrant survivors of sexual assault. My name is Hema Sarang-Saminsky, and I'm a senior attorney at the Victim Rights Law Center in our Boston office. My pronouns are she and they. And I've been an immigration attorney for about almost 15 years now. And my background is primarily representing survivors of intimate partner violence and sexual violence as they navigate through immigration systems. I also have a background in working with LGBTQ communities from a both community organizing perspective as well as direct legal representation. Please be mindful to request permission before distributing these materials. Our materials will be available in recorded form after this session. So if you are unable to listen today, you will have access to that, but we do encourage everyone's participation today. Thank you. Okay, so we're going to begin with a brief poll just to figure out who's in the room. The first question is, have you personally worked with immigrant survivors of sexual assault? Excellent. Great. So about 2/3 of you who've chimed in have, about a third haven't. Excellent. And the next question is sort of getting to the theme of today, which is the intersection between LGBTQ identity and immigrant identity. If you've personally worked with LGBTQ plus immigrant survivors of sexual assault. Okay. Great. Okay, thank you so much. Just as a brief show of hands, how many of you are attorneys in the room? You can use your hand-raising function at the top of your screen to indicate. So I'm assuming the majority of you then are advocates at this stage? Excellent. Okay, so let me move on to our objectives. We have many objectives. Our objectives are lofty today. We could cover this in a much longer training, and just to touch on some of the points we hope to cover today, we're going to be identifying the case impact when there is an intersection of LGBTQ plus identities and immigration status. We're also going to be talking about issue spotting, some of the remedies that are available for LGBTQ plus sexual assault survivors. And finally, we're going to delve into some of the unique safety planning and privacy considerations for LGBTQ immigrant survivors and talk about a bit of possibility for advocacy as well. For those of you who are immigration attorneys who have a pretty solid foundation on some of the humanitarian options for relief, please know that this will be more of a review when we get to the remedies section. That said, your perspectives and experiences in terms of how those remedies intersect with LGBTQ identities will be extremely helpful. Okay, I'd like to begin with a survivor's experience. So Luisa is, a compilation of a number of different clients I have worked with over the years. I'm going to read this out loud, but it's on your screen for you to read on your own as well. Luisa is 27 years old and is from Guatemala. She came to the U.S. when she was 20 years old after she fled her country. Her town in Guatemala is overwhelmed by gang presence. Luisa has known from a young age that her gender and sexuality are different from many of her peers. She has a more masculine gender expression and is attracted to women. Since she was 11 years old, she has endured sexual abuse by an uncle who would target her and tell her he could, quote, make her more womanly. She has not disclosed this abuse to anyone except you. When she was 16 years old, she was raped by two men who are known to be gang members in her community on her way home from school. They told her this is what people like her needed. They threatened to harm her family if she disclosed the assault. The men who assaulted her would frequently pass by her home and follow her on her way to and from school. Luisa was already having trouble at school with the discrimination she experienced from teachers and classmates because of how they perceived her sexual orientation and gender identity. These added threats led to a decision to drop out of school. Luisa became severely depressed and suicidal, and finally disclosed the rapes by the gang members to her mom. Her mother attempted to make a report to the police on Luisa's behalf, but was turned away. The police officers told her it was best for a girl like Luisa to remain quiet and perhaps leave the city since the gangs were so dangerous. With the help of her parents, Luisa makes arrangements to come to the U.S. She entered the U.S. in 2010 and then is stopped by Customs and Border Patrol, fingerprinted, and released. She lives in Boston, Massachusetts. She's referred to you by a local rape crisis center after being sexually assaulted by her employer 2 months ago. So this is a very common scenario, and I'm hoping that for folks who are on this webinar, that some of the facts and backgrounds and context for in this scenario seem familiar. So, feel free to use the chat box. We're here. We're a group of about 65, so there's many of us, but all of your perspectives will be extraordinarily helpful as we continue to talk about the unique intersections of these identities that Luisa holds as she navigates an immigration system. We're going to keep Luisa in mind as we go forward and come back to her as we talk about some of the common fears and barriers that she might be experiencing, the tactics used by perpetrators, forms of immigration relief that may be available to her, and how we might kind of think more holistically about our safety planning conversations with a survivor like Luisa. For those of you who are newer to working with LGBTQ plus folks generally, I would strongly encourage you to attend a webinar or training that gives you the 101 basics of language, of how to do holistic legal intake. Just last month we did do a webinar. It is available for distribution. There is a recording available, and we can share that with you if you reach out to us individually. That webinar really took participants through the basics of, how do you talk about sexual orientation and gender identity with survivors of sexual assault? What are the appropriate terms to be using right now, given that this is such a dynamic and evolving area for many advocates and individuals as we expand our notions of gender identity and sexual orientation? It talks a bit about how we can improve our intake and issue spotting abilities by incorporating a lens of the unique needs and oppressions faced by LGBTQ individuals. So please do reach out to us for that information if that's information that is newer to you. Okay. I'm going to jump into talking about LGBTQ immigrants in the U.S. So we know that LGBTQ folks and immigrants are targeted by perpetrators of sexual assault because of their identities. There is much data that supports an understanding of the dynamics of perpetration and victimization that show that perpetrators are quite strategic in targeting individuals that they perceive will be less credible in society, have less protections, and perhaps more vulnerable for a number of reasons on account of their identity, whether it be sexual orientation, undocumented immigration status, age, gender expression. All of those categories can certainly be factors that might come into why someone is targeted for perpetration. So as providers for sexual assault survivors, we need to be thinking about the ways in which our programs are open to, truly open to and accessible by immigrant survivors of sexual assault, and specifically LGBTQ immigrant survivors of sexual assault. If you're not seeing survivors who identify as LGBTQ coming into your programs, then I think that's a question to ask programmatically as to why. Why is that happening? Who are your partners? What do your outreach materials look like? What does your website look like? So, as TA providers for all of you, we certainly engage in one-on-one conversations as well as group calls on occasion to really talk through some of those strategies to, broaden the ability of your organization to best serve the most vulnerable survivors who desperately need services. So to talk just a bit about some statistics that have been collected through the Williams Institute and the Center for American Progress, it's estimated that there are 267,000 LGBTQ plus undocumented folks in the U.S. And that's out of a general population of about 900,000 LGBTQ adult immigrants. Again, it should be noted that when we look at these numbers, we need to factor in the reality that LGBTQ identities and relationships are still often invisible. There's this misconception that, just because same-sex marriage is legal, that, a lot of those concerns about invisibility are now gone. That's just not true. We see a growing anti-LGBTQ sentiment across the country in policies. And so we need to be thinking about the realities for LGBTQ individuals, and specifically naming trans folks of color who are still very much marginalized by current policies and laws that exist. I want to talk briefly about detention. So when we think about LGBTQ immigrants, I want to highlight the issue of detention briefly. And again, like I said before, this could be a webinar unto its own. But the issue of detention is very concerning, partly because when we think about transgender individuals, we know that trans folks experience disproportionately high rates of violence, generally high rates of sexual violence. When we talk about folks in a detention or prison setting, the realities for transgender individuals are that they are going to be much more likely, they're going to experience much higher rates of sexual victimization within a detention facility. Concerns for trans detainees in the immigration context are that they're not going to be provided access to adequate health care, that they're not going to be housed in a facility that is safest for them as they choose, that those who are HIV positive might not always be given their medication or their right to privacy, that issues of sexual victimization are not going to be taken as seriously. And certainly, as I've worked with transgender survivors who are denied access to life-saving medication, hormones, et cetera, that are really fundamental to who they are and what they need medically. So that's the why of why we need to be taking a look at this unique intersection of LGBTQ identities and immigrant identities as we think about, really creating a truly holistic and inclusive sexual assault legal practice. Okay, so I'd like to start with a kind of a background on some immigration systems terms. Sometimes immigration, as we know it, and certainly as it shows up in the media today, can be extraordinarily overwhelming. I mean, certainly as we hear survivors who contact us for services expressing such immense fear, oftentimes as advocates and even as attorneys newer to immigration law, issues of immigration feel very much like a, hot-button issue, because of what's at stake, almost unapproachable. So I'd like to break down some of the immigration systems terms for participants on this call today, just so we know some of the common acronyms and, who the players are when we are working with a survivor and trying to identify where they are in the process and what's happened, that we have some sense of, who the key players are in this very large and complex system. So folks have probably heard about INS from many decades ago. INS was the Immigration and Naturalization Service, and that was really done away with after 9/11, and it was replaced by the Department of Homeland Security. So as an umbrella, Department of Homeland Security, under that department, there are 3 sub-branches. One is ICE, or Immigration and Customs Enforcement. ICE are the folks who are really in charge of enforcement, as their name suggests, enforcement, detention, and removal. So when you hear about raids, when you see pictures of officers with the terms ICE police on their jackets, that's who we're talking about. They're the ones who are conducting the workplace enforcement raids, coming to knock on doors. They're the enforcement component of this agency. On the border, there's something called Customs and Border Patrol. Customs and Border Patrol has a more narrow jurisdiction. They're really in charge of enforcing border security. So at airports, near borders, near points of entry. Their jurisdiction lies within usually 100 miles of any border. And Customs and Border Patrol are often the folks that an individual may encounter. If someone talks to you and says, well, when I first came into the country, I was stopped by immigration, that's probably who they are talking about for the most part. So Department of Homeland Security is not just about enforcement. It also houses the United States Citizenship and Immigration Services, or USCIS. And USCIS, I guess you could think about it as, enforcement in a different context, enforcement of immigration law, which also includes remedies. So this is really where you are going to be able to apply for relief, for immigration options. When you hear someone talking about being recently married or sponsoring a relative, sponsoring a spouse, they are approaching USCIS for that benefit. Similarly, when someone is applying for their citizenship, that's the component of the agency that they are approaching for that relief. Now, separate from the Department of Homeland Security is the world of immigration court. So under immigration court is known as the Executive Office for Immigration Review. They are the immigration court, and then the appellate, there's the Board of Immigration Appeals, which is the appellate component of that system. EOIR is housed under the Department of Justice. So when someone talks about showing up in immigration court, that is the only context where they're going to see a judge. It's not an officer, it's not in an office, at a desk, it's a courtroom. Or it might be in a detention center where there's a courtroom in some detention centers. That proceeding is a proceeding between an immigrant client, known as a respondent in immigration court, versus the Department of Homeland Security, who is the opposing counsel. That is a right for any individual who, for a large percentage of immigrants. So you might hear survivors say, I don't want to just be picked up and deported immediately. In many scenarios, that's not the process that's going to happen. Unless someone has had prior contact with immigration, right? Prior contact with immigration where perhaps unbeknownst to them, they were told to go to court, they missed court, they didn't know about it, they were ordered deported or removed in their absence, they had no idea. And for that subsection of the population, those folks have lost their day in court. But for some exceptions where they can work with an attorney to try to get a second chance and reopen those cases, they are in kind of the more vulnerable scenario. So if you're hearing a survivor articulate, oh yeah, I was fingerprinted, oh yeah, I did, I spent a night in detention, but then they let me go and they gave me some papers, that's kind of a cue to you to be listening, to know that this individual might have what's called an outstanding removal order, right? So just something to file away and note as one of your issue spotting arsenal. For folks who've had zero contact with immigration ever before, no contact, in the event, for whatever reason, they come into contact with one of these with the Immigration and Customs Enforcement arm, then what's going to happen to them is they're going to be told that they have to appear in court. They may be detained, and we'll talk a bit more about what the realities, how those realities have shifted for many individuals in their present climate. They may or may not be detained, depending on the circumstances, depending on which officer they run into, but they will have an opportunity to have their day in court that usually stretches over a course of many years, to argue before a judge all of the reasons they believe they have a right to remain in the U.S. And that could be raising evidence of their eligibility for relief on a number of fronts. It could be, I'm a victim of sexual assault. Here are the forms of relief that I qualify for. Or my parent's a U.S. citizen. They're going to petition for me. I want relief through my parent. So a number of scenarios might apply to a particular individual where they can request relief. Any questions on the immigration systems piece before I move on? Great. Okay, so I'm going to transition to a conversation about some of the barriers that LGBTQ plus immigrant survivors face when navigating these systems that we speak of, and also talk briefly about some of the more recent changes in policy that have really kind of heightened the anxiety for so many survivors we work with, and honestly advocates and attorneys as well. So we're gonna unpack a bit of that, but first, we're going to talk about some of the fears and barriers and what those are. And I'd love to hear what you are seeing and hearing by way of these fears, how that shows up in your practices as well. So I see the chat is quiet, and please do feel free to chime in. Okay. I can't talk about immigration systems and LGBTQ identities without contextualizing all of this in this notion of institutional oppression. So defined pretty simply, institutional oppression is the racism, sexism, xenophobia, homo, bi, and transphobia, ageism, ableism, all of the isms that show up in the policies or practices of institutions. So institutions are a number of things. They are the immigration system, as we just spoke of. They are courts, hospitals, social services organizations, legal services organizations. So all of these institutions, educational institutions that are really kind of foundational to day-to-day living. It's what we walk through in our daily life. We could map the number of institutions we come into contact with over the course of a year, right? So, our clients, especially those with multiple marginalized identities, as we're talking about today, LGBTQ and immigrant identities, they face these oppressions and really try to tell us about them whenever in our day-to-day meetings. And it's really up to us to listen to that. Sometimes it might not come across. I mean, no one's going to articulate their experiences necessarily of, I think I experienced institutional oppression when I went to that particular hospital. But there may be a sense in communities that certain hospitals are less safe, not as accessible, not as welcoming to LGBTQ folks, or certain programs really aren't going to be great to go to for immigrant communities or non-English speaking folks or trans women, right? These reputations build in small communities and out of experience, out of the lived realities of the folks who have the most at stake when navigating them. So, I want to encourage all of us to really see this as foundational to our work as lawyers, to our work as advocates in our ability to competently and safely serve LGBTQ and immigrant individuals. We want to make sure in this climate that we're not compromising the safety of survivors by missing some key aspect of their experience. So please do, so what I mean by that is, for example, referring a trans woman to a particular counseling program, say, that unbeknownst to you, might not be welcoming of trans individuals, that might not have Spanish-speaking receptionists who would be able to actually serve that individual. There's so many contexts in which that initial outreach that a survivor makes could make or break their ability or interest in continuing to seek services. So, we talk in our work a lot about this idea of making sure we're doing warm referrals. And what that means as individuals who are, privileged to have access to these other institutions is to do our homework, to call, to ask these questions about, how do you, have you worked with LGBTQ survivors? So if someone calls and they didn't speak English, who would they contact? What's the process? How does it work? So feel free to, use your access to best support these survivors. Also, again, plugging our TA, please do reach out to us. This is something that I love to talk about with grantees, and I'm happy to help, kind of free think with you as you imagine how you could make your program or your practice better. And there is, zero judgment here. I mean, we're all in the process of improving our accessibility to all survivors. And this is our collective work and our collective obligation. So it's, I love when grantees reach out to us to ask these critical questions. Okay. So common fears. I mean, some of these are going to seem, fairly commonplace given what's going on in the world. But when we talk about common fears, we're taking the context of anti-immigrant sentiment plus homo, bi, and transphobia, and all of that equals a fear of deportation. That is the greatest fear that we hear coming up. For an LGBTQ immigrant to face removal to a country that in which a country they may have actually fled from, where it may be unsafe for them to live as they are, in the expression of their gender that they live in day to day, that can be life or death, right? All of these concerns about deportation really come down to they are life or death fears and for good reason for many, many survivors. Many survivors articulate a fear of family or community separation. We know the issue of family separation has very much been in the news of late. Fear of retaliation by a perpetrator or offender against family in the home country. So we're going to talk a bit about, criminal justice advocacy and thinking about, well, what does it mean to go through a criminal justice process against a perpetrator when potentially that perpetrator themselves may be in a position of being returned to a home country and could cause further damage there. And finally, shame, social stigma, a history of not being believed. We know we have, the Me Too movement has, just highlighted what I think, what so many of us in this work know, which is sexual assault survivors are often not believed, that the voices of sexual assault survivors are often silenced. And when we add the intersecting of oppressions of LGBTQ identities and immigrant identities to that mix, then the level of silencing that an individual can experience, a level of disbelief that an individual can experience, is just further heightened. Okay, so I want to talk a bit about some of the news that is currently that's come up. So when we talk about, I'm talking about what's new in the world of immigration. I see that part of the heightened concern, really stems from two memos that were issued immediately in January of 2017. And what these memos essentially did were to really change the practice of immigration enforcement fairly fundamentally. One of these memos, the Interior Enforcement Memo, really basically stated that the previous administration had used a priority enforcement program. And priority enforcement program, it didn't mean that, folks were not flagged for detention and removal in prior administrations. That was always true, and that has continued to be true. The difference was that there was sort of a tiered system for enforcement. And what the tiered system means was that there would be individuals sort of at the top of the enforcement priority who potentially had more serious criminal histories, folks who were very, very recent entrants. And then at the bottom of that kind of hierarchy were folks who had really been here for a long time, maybe had very little to no criminal history. It wasn't a perfect system by any means, but it was a way in which, for many survivors of sexual violence and domestic violence, we noticed that folks were not typically being detained and flagged for removal. They would have enough time and space to access the forms of relief that we're going to talk about. I will get to it. Before having to face some of those more adversarial processes. I'm speaking very, very generally, and there are folks who have been doing detained work on behalf of survivors for a long time, but there was a lot more kind of, at least there was a sense of an order. What's happened more recently is that that notion of there being priorities for enforcement is gone. There are no longer. It's in many ways it can be understood as everyone who is undocumented is a priority. folks who have criminal histories, folks who are suspected of having criminal histories, people who are undocumented for any amount of time. Everyone is essentially a priority, including survivors of sexual assault and domestic violence. While that's not named explicitly, there is no carve-out in that. Another recent development is a conversation around the issuance of notices to appear, or NTAs. And so what that means is when people apply for immigration relief, there is a way in which, at least in the humanitarian section with Vermont Service Center, there was a sense for many years that because Congress intended these forms of relief that we're going to talk about, because Congress intended for those forms of relief to be accessible by the largest number of immigrant survivors, it wouldn't make sense to then potentially flag individuals who apply who might have weaker cases for deportation or removal. There's been some recent policy memo on the issuance of notices to appear that sort of throw that assumption into question. Again, there are a number of advocates who are experts on doing kind of a gender-based violence-specific forms of immigration advocacy, who are very much in conversation about what the realities of those memos are in terms of our practice. But we are now more than ever far less able to reassure survivors that the likelihood of pursuing a form of relief is going to result in a very low risk level of enforcement. We can't do that. I mean, we could obviously never give guarantees, even previously, but the ability to offer some guidance to survivors has really changed in the past 2 years. Okay. So I want to spend a little bit of time talking about, now that we've talked about this background of these immigration systems, let's talk a little bit about some of the ways in which LGBTQ identity can intersect with immigrant identity. I think I'm having a hard time seeing folks chat in the chat room. I believe that people are chiming in and I don't end up seeing it, but I am going to talk a bit about the ways in which, let's take a look at employment, for example. So if we take a look at employment, what are some of the ways in which you could imagine, thinking about a survivor like Luisa or survivors you've worked with, what are ways in which employment, in the context of employment, how might LGBTQ identity intersect with immigration status? What might a survivor be saying to you that would make you think that this intersection is at play? Great. If folks are typing, I unfortunately am not able to see your chat responses for some reason, but I'm going to continue to just talk through some of the intersections that have come up as we move through this. Okay, so currently, one issue that comes up often in the employment context is the reality that currently there are only 20 states plus DC that explicitly prohibit discrimination against discrimination on the basis of sexual orientation and gender expression. Only 20 states. And there's a common misconception that that number is much higher. Oftentimes, LGBTQ survivors and immigrant survivors tell us that, they're not, for example, if they're assaulted on the job, the likelihood that they will feel comfortable telling an employer or HR that they were assaulted on the job is very low for many reasons. Perhaps they're not out of the workplace. Perhaps they know that the individual who assaulted them has power to control their hours, to control their access to desirable shifts. We see often in the context of employment retaliation. For the purposes of when we're talking about immigrant survivors and immigrant access to employment, we know that there are limited options for undocumented individuals to access employment. So for an immigrant survivor to be able to access another job, the idea of simply leaving one's employment and moving on to a different place of employment is not an option for many survivors generally, but certainly far more limited for immigrant survivors. Okay. Some of the terms that I would recommend, when you see individuals, when you're working with individuals in the employment context who are saying things like, I'm just not comfortable on the job, I'm not feeling like things are going right, just listening for the ways in which someone's experience of sexual assault is playing out in the employment context. That could be related to, specifically to a perpetrator who is in that place of work. It could also relate to an individual who has experienced an assault outside of the workplace, but potentially is having a hard time maintaining a level of performance required for their place of work, whatever is required. So those kinds of retaliatory circumstances may arise. When we talk about LGBTQ identity and immigrant identity, we always need to talk about credibility too. Oftentimes, employers will instill in immigrant survivors that they're just not going to be believed. Same thing with LGBTQ survivors, that they're just not going to be believed because of who they are. Why would anyone believe you because of your identity? Moving on to the education context. Oftentimes, immigrants currently 36 states don't ban discrimination on the basis of sexual orientation in education. And that is of huge concern. Individuals who are on student visas, who are immigrants, face some unique barriers to accessing some of the remedies that might be available through their particular campus process. So individuals who are on student visas, for example, may not be able to take a leave of absence in the way that other survivors might be able to, for risk of violating the terms of their student visa and falling out of status. Many LGBTQ individuals on campus also talk about a lack of awareness of the dynamics and realities of LGBTQ sexual assault. There's a lot of invisibility among male survivors, among LGBTQ survivors, and concerns that their stories, their experiences will not be taken seriously. I also just want to flag briefly in the education context when we talk about this intersection of LGBTQ identity and immigrant identity. DACA impacts such a huge number of young folks, a significant portion of whom are LGBTQ identified, and to think about the realities that, only 16, potentially up to 20 states extend in-state tuition to DACA recipients is significant in terms of thinking about the limitations on access to education for individuals who may have no other option but DACA to pursue higher education. Okay. So criminal advocacy, when we talk about some tips on, best practices when advocating for LGBTQ immigrants in the criminal advocacy context, we need to start with safety. As I mentioned, we know that LGBTQ immigrants are at far more likely to be targeted for victimization by perpetrators because of their vulnerability in society generally. Currently, we hear many survivors we're working with talk about their concerns about ICE presence in courts. What this looks like, oftentimes for those who are trying to obtain sexual assault protection orders, that might be at your local district court. And in our courts, for example, it is routine that Immigration and Customs Enforcement is present. Not particularly attempting to target individuals who are there to obtain civil protection orders, but for other reasons, but their mere presence has such a significant chilling effect on survivors who are attempting to access relief. Other considerations are, what are your courts like? What do you know your courts to be like? Have you done court watches on your own? How are folks who identify as LGBTQ being treated in the courts where you are? How are immigrants who potentially require translators being treated in the courts in your jurisdiction? How do judges deal with a survivor who has a particular request around pronouns they want used during a proceeding? What does that look like? And what can our responsibility be to sort of vet those courts initially to be able to best advise survivors of what they might be able to expect when navigating those systems? Okay. When we think about housing, I was just looking at some realities of the number of landlords who are turning to using immigration status as a means of eviction. So landlords will commonly, more and more commonly, unfortunately, in this climate, basically state that, they want proof of status, which, they're certainly not allowed to ask, but they want it, that they have the power to call Immigration and Customs Enforcement on anyone who is living in their building who is undocumented. And just the mere mention of that creates such widespread panic for so many undocumented individuals. That coupled with the fact that many jurisdictions don't have explicit LGBTQ plus non-discrimination provisions makes the impact of these intersecting identities on housing-related issues even more significant for LGBTQ immigrant survivors. I just want to touch briefly on privacy. We're going to be doing a whole webinar on August 17th, which will, share the information at the end of this webinar about that really talk about the intersections of immigrant identity with privacy-related issues. Just to do a one-sentence summary of what some of the issues that will come up, given the heightened concerns for so many immigrant survivors in the current climate, the importance of maintaining survivor confidentiality, informing survivors of their rights around privacy are more important than ever. There are, as VAWA-funded programs, we have particular requirements to maintain survivor privacy, to never reveal personally identifying information without written releases that conform to some pretty specific requirements. So we want to be keeping in mind the ways in which, especially in small communities, just a bit of information, even information that may not on its face seem personally identifying, might in fact become personally identifying in a small community with a particular set of facts, right? And there's a common sense of a rule of three that refers to when talking about trans individuals in a small community, 3 pieces of information, even if not explicitly identifying, may be sufficient to inform a community of who is being talked about. So back to Luisa. All of this background that we have covered up until this point, I want us to, encourage all of you to incorporate this, begin to incorporate some of these questions and, even additional questions that this has generated for you in your programs. Think about how a survivor like Luisa might feel when coming to your program. How will you ask her about her identities, her pronouns, her experiences as an undocumented individual who is LGBTQ identified now in the U.S.? For Luisa, a number of the kind of new policy shifts that we spoke of will come into play. We know we're gonna unpack a bit more about the options that exist for Luisa in just a moment. But from the description that I offered on Luisa's experience, we know that on at least one occasion, Luisa was stopped by immigration officers when she was entering the U.S. That is going to be significant for her. That could potentially mean that she has what's called a prior order of removal. We're going to keep in mind for a survivor like Luisa how we continue to issue shot and ask questions that will help us understand the kinds of remedies that she will be eventually eligible for. I want to add that, in some, there are potential, additional, survivors are not, survivors are human, right? So in this, some of the potential issues that may arise that are going to be left very much as questions to watch as immigration policy evolves. What would happen, for example, if Luisa had used some fake documents in order to obtain the work that she was able to get, and she used that to support her family back in her home country? What happens if she was arrested once for driving without a license? What if she lives in a more rural area that requires her to drive in order to get to work? How do those daily acts, just those day-to-day acts of living, potentially leave her more exposed to potential immigration enforcement? Okay, so I'm going to move on to the options section. I'm sorry for folks who are typing into the chat section. For some reason on my view, I'm unable to see your chats, but we're working behind the scenes to collect your questions, so I'm able to answer them individually. Apologies for that. Okay, still options that exist. We're going to talk about the options that we're going to address today are, and this is my I Heart VAWA slide. Okay, so we're going to talk a bit about asylum, partly because asylum related to survivors of violence has very much recently been in the news. We're going to talk about U visas T visas, and then VAWA self-petition. We're going to address these one by one, and I'm going to start with asylum. So asylum made its way very prominently into conversation among immigration attorneys, advocates, the national media recently with the case of Matter of AB. Matter of AB was very monumental in a number of ways, and we also want to what I'm going to do in the course of this conversation is to talk about what it was and what it also was not. The reality is that asylum still very much does exist. It is certainly a strong and viable option for survivors of sexual assault, of domestic violence, LGBTQ survivors in particular. A number of LGBTQ survivors of sexual assault have successfully obtained asylum in the U.S. So asylum still exists, and that's one major take-home that I want folks to have to come away with today. I can see your chats now, I believe. Oh, great. Excellent. I'm so excited. I saw Hanya Luna's comment just now, and I think that's the first comment I've seen, and I will continue to respond as we go through this webinar. Okay. So let's talk about asylum generally. So asylum, in a nutshell, is an individual who has experienced harm in the past or has well-founded fear of harm in the future and can show that that harm is because of their race, their religion, their nationality, their political opinion, or this nebulous category called membership in a particular social group. If you can show that you've been harmed because of one of those areas, and you can show that the government is unwilling or unable to protect you, you may qualify for asylum. The issue around the particular social group conversation is really what was discussed in the most recent case of Matter of AB, which just came down in June of this year. So membership in a particular social group has been a category under which we as asylum practitioners have argued that survivors of domestic violence, so for example, Guatemalan women who have experienced domestic violence may qualify for asylum because they were targeted as Guatemalan women and targeted with extreme domestic violence over many years. We've very clearly been able to show that the government has been unwilling or unable to protect them, as documented by their efforts to seek out relief, contact the police, the number of times they've been turned away by police, the fact that no one in their right minds would contact the police in their home country. By putting together a narrative that sort of meets each of these elements, we've had success on many fronts in obtaining asylum for individuals who are survivors of sexual and domestic violence. In terms of LGBTQ identity, I've worked with a number of survivors who were, targeted for persecution because they were starting from a young age, whether by family members or classmates or gang members like Luisa, targeted so systematically and experienced systematic violence in a number of different ways on account of their gender expression and or their sexual orientation. The one hook with asylum is this issue that you have to apply within 1 year of entering the country. So this has always been a challenging component of asylum law since '96. And the problem with the 1-year filing deadline is you're essentially putting the burden on an extraordinarily traumatized individual to apply for asylum within 1 year of coming into a new country after you have fled a country that has systematically harmed you and where you had no protection. So it's a very, very immense burden to overcome. There are exceptions to the 1-year filing deadline due to either changed circumstances, but also due to extraordinary circumstances like your level of trauma. So we have in a number of scenarios historically been able to overcome a 1-year filing deadline by showing that this individual, especially working with survivors who are traumatized from very young ages, that the fact that they did not apply within 1 year of their entry is entirely understandable, and in fact that they weren't able to process that level of trauma until they were able to be connected to services and support to begin to heal from some of that sexual violence after entering the U.S. Okay. Any questions on asylum before I move on? Oh, I see 2 questions. I'm going to take a moment now that I can see your chat. I'm so excited. Somebody had asked me if I could explain what court watches are. I think court watches, I was using the term informally for probably programs that exist more formally out there. But I think the idea is, could you as an organization, could all of us, especially folks who are working with survivors who are navigating courts on a daily basis, do we have a sense of what survivors are experiencing in those courtrooms? Can we collect data informally among, in our state, for example, that kind of provide a map of which courts are more friendly to LGBTQ or immigrant survivors, which places are less friendly, who's less friendly, why. It's sort of forming the basis of, again, as we talk about all of our work with survivors, we want survivors to walk into any context eyes wide open. Right? We don't want to provide, a false sense of safety or security from an institution that might not be able to provide that. So, we do a lot of work with survivors of really talking them through what they might expect, and part of that expectation may be navigating, well, what happens if something anti-immigrant or transphobic comes up? I see another question about whether someone with a pending U visa can apply for Section 8. The answer is you can't apply for Section 8 with a pending U visa. There are certain states that have expanded state public benefits to U visa grantees. I believe California has done so. I'm not sure if there's other states who have made that move. But in terms of Section 8, which is a federal benefit, that is something that is not available to folks with pending U visas. Thanks, Rachel, also for that. Okay. So how do we overcome these new kind of limitations on asylum? What Matter of AB did was, a lot of folks kind of had a momentary pause when this decision came out because it felt like asylum based on domestic violence was now gone. That is not our reading of this case. What it is a reminder that, to me, that we are experts in the dynamics of victimization and perpetration, and we need to be using that expertise to build stronger cases, to advocate even harder for this form of relief for sexual assault survivors. Okay. We can do that by really knowing the case law associated with asylum, thinking about additional ways in which we're going to corroborate the harm that survivors experience, whether that's through expert testimony and moving in that direction again, additional witnesses to the violence or to an individual's recovery from trauma. there's a number of ways in which we can kind of build stronger cases, and there's a network of attorneys who are actively sharing our strategies for approaching these cases, and feel free to reach out to us if you have a LGBTQ focused asylum case that is dealing with a history of victimization, sexual victimization, or domestic violence. Please do reach out to us, and we can talk through, how best to approach these cases. Okay. So U visa. I'm going to talk about the U visa. I used to call the U visa the unicorn visa. It's less of a unicorn now, but it's a temporary visa. It's good for 4 years. It's a pathway to lawful permanent residence after 3 years of having it. And you can include some family members. And it's specifically for victims of qualifying crimes, and there's a whole list of crimes, who have been helpful to law enforcement and have suffered physical or emotional harm as a result of that victimization. What you get if you are able to show each of these elements is a 3-year visa, or 4-year visa, and an opportunity to apply for lawful permanent residence after 3 years. I'm going to just talk through each of these statutory requirements and then speak of the unfortunate time issue that has come up more recently with U visas. So first, you have to be a victim of a qualifying crime, and that includes crimes such as rape, trafficking, incest, domestic violence, sexual assault. And you can either be a direct victim or an indirect victim. And what an indirect victim is so say I am an undocumented individual and my U.S. citizen child, who is 3 years old, was the victim of a sexual assault. I'm the one who is obviously going to be in communication with law enforcement regarding that victimization, offering my assistance in the investigation and prosecution of that crime. My child will not be able to do so. So because it's the adult who is the indirect victim participating, they too could qualify potentially for this visa based on their assistance in the investigation and prosecution of these crimes. The U visa is really based on this law enforcement hook. So you have to show helpfulness to law enforcement, and that comes, the way to demonstrate helpfulness is by getting a certification from a law enforcement agency. That can be police, prosecution. In some states, it can involve Children and Family Services, or DCF, as we call it in Massachusetts. It can include EEOC certification, Department of Labor. There's a number of certifying agencies. Judges in some jurisdictions have successfully certified. They provide a piece of paper as a document. It's a form. It's an immigration form. And that becomes part of your filing. And finally, you have to show substantial physical or emotional harm. And that substantial physical or emotional harm, can be primarily shown in the form of the victim's declaration. It can also be shown through a letter from a counselor or medical records of the harm that the individual suffered. As a U visa applicant, you also have the opportunity to include family members, and that it can include your spouse, your children, and if you are a younger applicant, you can also include your siblings. Okay. So in terms of issue spotting for the U, that's the super fast version of the U. And I think one of the, if you're working with an undocumented individual who is, or any individual who is a victim of a crime that happened in the U.S., I think that is your primary, alert that a U visa may be on the horizon. So keeping that in mind. The unfortunate issue with youth right now is that there's a huge backlog. There's a limit of 10,000 per year that was statutorily allowed, and those 10,000 a year have been consumed many years in advance. And so every year the wait for a U becomes exponentially higher. So currently what's happening is it's probably looking about 6 or so years before someone is actually going to see a U visa from the time they apply. What has been allowed in the interim is after a couple years, you may be placed on a waiting list for this U visa. And when you are placed on that waiting list, then you are eligible for employment authorization. But survivors who apply for this form of relief have a number of years before they even see a work permit. Yeah, 10 years. I mean, it keeps going. I'm still in 6 because that's what I told clients more recently. But yeah, it's longer and longer. Okay, so I'm going to move to issue spotting for the T visa. T visa is a trafficking visa and very similarly structured to the U. It's also a temporary visa that's for up to 4 years, but it's also a pathway to permanent residence after 3, and you can include family members. For a T, you have to be the victim of either sex or labor trafficking, present in the U.S. as a result of the trafficking, that you have complied with reasonable requests for assistance in the investigation or prosecution, that you would suffer extreme hardship if removed from the U.S., and that you have to be admissible. Admissible means, it's an analysis of a section of the Immigration and Nationality Act to see, whether you have certain crimes on your record, an analysis of all of these so-called grounds of inadmissibility that become bars, that are typically bars to obtaining any kind of immigration status. With both the U visa and the T visa, there are very generous waivers of those grounds of inadmissibility. So even if individuals, for example, came into the United States without inspection, without documents, or have certain criminal histories, those waivers are fairly generous or have been to date. One thing to note with the T, I'm going to talk a bit about the forms of trafficking and what we mean when we talk about trafficking itself. I think there's a lot of folks who don't utilize the T visa nearly enough. The regulations for the T are very, very expansive, much more expansive than I think we would have previously thought they might be. It's been shared with us by Vermont Service Center adjudicators that where all of these cases are processed, these are USCIS adjudicators, that they see a lot of cases that are filed as U visas that really could have been Ts. And the interesting thing about the T visas is there is no backlog right now, though that cap never gets reached for the Ts because people aren't filing them as much. Another plus for T visas is that you don't need to have that law enforcement certification. You still, in many cases, have to show that you've tried to obtain it and that you've provided assistance, reasonable assistance with law enforcement, but there's more flexibility in that arena. So when I talk about sex trafficking can be, it really comes down to a commercial sex act. And a commercial sex act is any sex act on account of which anything of value is given to or received by any person. And it needs to be induced by force, fraud, or coercion, or the individual was under 18. And in those scenarios, you don't have to show force, fraud, or coercion. So if you take that definition, we have worked with a survivor, for example, who is was assaulted by a landlord, and the landlord essentially told her that she was, if she didn't want to be homeless, she could either live rent-free in this apartment, perform sexual acts for this landlord, or face eviction and be homeless. So in that kind of a scenario, we're making a T argument in this particular case. I see a question here. If a client is facing removal proceedings and a client received a certification from police, will immigration court still proceed with the removal case? It really depends on your jurisdiction, right? The short answer is they should. The reality that we're seeing in some areas, in Boston, for example, Boston immigration courts have been typically fairly lenient in continuing the case, year after year to allow that individual to obtain the relief they need. In other jurisdictions, that's not happening, and Department of Homeland Security's position is that an individual can wait for their U visa in their home country. They don't need to be in the U.S. for that, which obviously is, contrary to congressional intent in so many ways. It was not the intent of the U visa to look at it from that perspective. Okay, so let's talk about presence in the U.S. The idea that someone needs to be present in the U.S. as a victim of trafficking or due to the trafficking, again, much more expansive than was previously thought. It could have been entry into the U.S. to participate because of the trafficking itself, but it could also mean that someone was trafficked here, that they have left the trafficking scenario but are now experiencing extreme poverty or trauma and are seeking services. So they are here in the U.S. as a result of the trafficking. That nexus is far easier you can make the case in a number of scenarios that might implicate issues of trauma, poverty, etc., all of the aftermath of victimization. In terms of the cooperation requirement, the law enforcement certification is not required, but you do have to show that the trafficking was reported and that the individual is willing to cooperate, unless you're a minor or have such extreme trauma that is not possible. And finally, you're showing extreme and unusual hardship, which is a range of factors that are, honestly quite commonplace with most survivors of sexual assault and trafficking, that the extent of trauma, the impact of losing access to mental health services if removed to your home country, what happens if there's retaliation by the trafficker, losing access to a U.S. court system and the protections that are available here. So many resources there. Okay. So VAWA self-petition and issue spotting. If you're working with an LGBTQ immigrant survivor who is talking about a marriage to an abusive U.S. citizen or a green card holder, that is your primary way of issue spotting eligibility for something called the VAWA self-petition. Now LGBTQ partner abuse very much exists. It exists at about the same rate as the general population. 25 to 33% of LGBTQ individuals will experience partner abuse in their lifetime. So again, it's up to us to ensure that we're screening LGBTQ individuals for histories of domestic and sexual violence as well. And sometimes that is missed by many providers who don't think about the dynamic of abuse outside of a heterosexual relationship. The vow of self-petition it's really models a family-based immigration process. So usually in a family-based immigration process, there is a petitioner who petitions for an immigrant spouse, and that immigrant spouse has the opportunity to kind of go through the process, establish that they were married for legitimate reasons, not just for immigration purposes, and that they have an intent to establish a life together. The issue is that U.S. citizen spouse or that green card holder spouse really controls the process. Because they control the process so thoroughly, oftentimes when there are dynamics of abusive power and control at work in that relationship, if that U.S. citizen is exercising abusive power and control over the immigrant spouse, a lot of times this process itself can become another part of a tactic of abuse. So oftentimes we'll hear survivors talk about their abusers saying things like, well, if you ever say what I'm doing to your family or talk to the police, I'm going to make sure you don't get your green card, or I'm going to stop the process, right? That is why the vow of self-petition was created. It was really a mechanism to put that family-based immigration process back into the hands of a survivor of domestic violence. So that survivor then controls that process through a vow of self-petition. You petition for yourself. In terms of issue spotting eligibility, I mean, if you haven't seen the Immigration Power and Control Wheel, it's worth taking a look at the variety of tactics of abuse that can be used. There are LGBTQ-specific tactics of partner abuse that are available in similar wheels like this too, I believe also through Futures. And to be eligible, I mean, you have to show that you have a qualifying relationship to an abusive U.S. citizen or green card holder, that you have been a survivor of battering or extreme mental cruelty, so the whole range of physical and emotional tactics of power and control, that you were, in fact, intending to enter into a good faith marriage, that it wasn't just for immigration purposes, that you live together, and that you're what's called a person of good moral character. And again, that's taking a look at your any criminal history or issues of fraud on your record. Which again, don't mean that that you have to have an absolutely clean record. It really is a case-by-case analysis of taking a look at your history, your criminal history, any fraud or misrepresentation that may exist on your record, etc. When you go through that process, you are essentially on track to obtain the green card that you would have otherwise been eligible to obtain through that abusive spouse or parent. I'm going to skip through some of the ways of proving battering or extreme cruelty. Feel free to reach out to me to talk through some of this. These slides are also kind of a nice checklist to go through some of the common forms of evidence that we use. The nice thing about vow of self-petitions is that the evidence that USCIS will accept of dynamic of partner abuse is any credible evidence. So oftentimes the survivor's declaration is one of the most significant pieces of evidence submitted. So really working with a survivor to create the strongest document possible goes a long way towards a successful application. I skipped over the slide on special immigrant juvenile status, but I just wanted to mention, if you're working with LGBTQ immigrant youth, it's always a good idea. I mean, many LGBTQ immigrant youth face homelessness or family rejection and may be in scenarios where they may be eligible for something called special immigrant juvenile status. And that is a type of relief that invokes the power of your family courts in conjunction with USCIS. So by basically establishing that an individual was abandoned, abused, or neglected by one or both parents, a minor has the option of potentially putting themselves on a path towards lawful permanent residence. Okay. I want to spend the last 5 minutes we have talking about some of the safety planning considerations that we want to keep in mind as we begin to counsel immigrant survivors. For VAWA confidentiality, VAWA confidentiality specific to forms of immigration relief are, they are statutory confidentiality protections for survivors of, for the range of survivors of sexual and domestic violence. And I want to say we will be doing this webinar that will dive much more deeply into the specifics on VAWA confidentiality on August 17th. So I just want to put this here that there are protections that are statutorily specified that do protect applicants from information that may otherwise come from a perpetrator or an abuser. That's one of the strongest pieces of protection under VAWA confidentiality, and I want to just flag that for folks. So if a perpetrator is trying to interfere with a process, information obtained by that perpetrator cannot be used as the sole source of information to discredit a survivor's application. Similarly, no information can be shared with a perpetrator. Okay. When we're talking about safety planning, I think, keeping some of this backdrop in mind that we talked about, the realities of immigrant identity, of LGBTQ identity, sort of the range of institutional forms of oppression that an immigrant or LGBTQ individual face as they navigate the world, needs to be the foundation of our safety planning. Undocumented immigrants have always been safety planning. As long as I've done this, I've worked with survivors who've talked about, well, I don't know, should I apply for the U visa or not? Do I want to make the police report or not? Is that going to be safe? That is a constant question that comes up for survivors. I think the practical pieces that we can support survivors in is to really know our resources, to know our communities, to build relationships with community partners, work more closely together to ensure that our network of services in our particular community are as LGBTQ and immigrant friendly as possible. And that might take some work and partnership with an LGBTQ or immigrant specific organization to say, can you help us? Can we take a look at our materials together? Could we hire you to do sort of a document review for us to examine are our services accessible? But overall, survivors are experts on their own lives and experiences. So it's again, a survivor knows best about their safety and what institutions are or are not safe. And to be open to that information from a survivor can be hugely empowering to an individual. And also to let a survivor know that you are watching your community partners to understand which places are good places to refer to and which aren't, and how we can do better. Just very briefly in terms of, just some of the practicalities of documents, information. These are just some tips on kind of enhanced safety planning. You can encourage survivors to organize important documents, know where their passports are, their medical records, prescriptions. Having prescriptions and medical records available for LGBTQ immigrants who might be at risk of detention can be very, very helpful, because if an individual needs to access particular medication, the delay between their detention and ability to potentially access hormones or other medication they need can be minimized if that information is easily accessible by someone that individual trusts. To know by heart the name and phone number of an attorney, right? Not just the numbers in our cell phone, but actually committed to memory. Is there a loved one or family member, somebody who can know that individuals, if they have an alien registration number, which is a number identified by immigration, can that be specified? Always, always get advice before advising someone to travel outside of the U.S. That's a big one. I mean, I think, given the level of trauma and fear in our communities, I've heard a lot of survivors saying, well, what if I just go? Like, I'm just going to go, I'm going to leave, maybe I'll come back some other time, I can't do it right now. And that's a valid choice, and the implications of what it would mean to them if they could not return sometimes are very significant, so we need to have some critical conversations about that. I'm going to point us in the direction of a couple resources that I love. Asista has an excellent clearinghouse and are really expert TA providers on all things VAWA UNT. NEWAP also similarly has excellent resources on VAWA confidentiality. The Immigrant Legal Resource Center is just a wealth of information on news and updates on how some policy shifts are impacting immigrants generally. And the American Immigration Council, I found, has some pretty excellent practice advisories on, how we can be, doing some cutting-edge immigration lawyering in the face of current policy shifts. So I just wanted to flag those for you. And that's it. And we don't have time for questions because this was trying to fit in a 3-hour webinar into an hour and a half, but I wanted you all to have as much background as possible. We are TA providers and do want to truly encourage you to call us. On immigration matters, you'll probably speak with me, and we can set up a time to call, do a half an hour, 45-minute, hour-long call, going through your particular case questions, practice tips. So please do reach out, and I'm going to point you to our TA page right here, ta@victimrights.org. And thank you all so much. And I apologize for those questions I might have missed early on, but again, do reach out. And please fill out an evaluation. It's extraordinarily useful for us to be able to add to and develop our trainings. And I love getting feedback and hearing from all of you. Thank you so much.